That is, yeah. Yeah.
Good evening, everybody, or good afternoon. The format will be fairly businesslike. We'll be straight into it. It's just me and Bronwyn, and you don't need to know anything else about us. I'm sure you've all been to a CPD about a new practice direction or a new piece of legislation where somebody has very helpfully read out the practice direction or the new piece of legislation and told you what Section 27 contains. So it's in front of you. Well, that won't be happening. Bronwyn will talk you through some of the more practical aspects of the new practice direction and has some visuals to assist in explaining the new forms that will be in use. I'm going to just begin, though, by giving you some background and a bit of an overview. And there's no better way of doing that, I think, than giving you some statistics or some raw data, starting with the proposition that between the 1st of July last year, 2023, and today, 77 matters were listed for trial in the Supreme Court of Queensland. A full 36 of that 77 went ahead as listed. That is to say, 41 of those trials did not proceed. More than half of the matters listed for trial did not proceed at the time they were meant to go ahead. For the hearing of those 41 trials, more than 250 court days were set aside. So 50 weeks of judge time set aside for trials that did not go ahead. The figure is actually probably 270, but for tonight's purposes, all of the statistics I'm going to quote are conservative. For my own purposes, I categorised the trials that did not proceed into one of four groups. There were those in which a plea of guilty was entered to the indictment as it read. Shorthand, the defendant gave up, said fair cop, plea of guilty to everything, should always have been that case. At least 35 days were set aside for those matters, so 7 weeks of judge time. And when I talk about judge time, can I just ask you to perhaps conceptualise what that means? Just think of what it would be to have a judge sitting in a courtroom day after day for 7 weeks doing nothing, between 10 and 4:30. Just have a judge sitting there. That's the sort of vacant space we're talking about. The next category of those trials that didn't proceed were the ones in which the DPP entered a nolle prosequi and discontinued proceedings altogether. Shorthand read, the Crown gave up completely. Coincidentally, 35 days were set aside for those trials, another 7 weeks of judge time. Then there were those cases where some ground was given on both sides. So a plea entered to some, others discontinued. 70 days were set aside for those, some 14 weeks of judge time. And then there were those that were simply adjourned for any number of reasons, some clearly legitimate, others less so. And at least 100 days, 20 weeks of judge time were set aside for those trials. So that's a total of 240 days out of the 250 I mentioned earlier. As I say, these figures are conservative. Where I couldn't be certain about the category to put them in, I just left them out. And I have not attempted to calculate the amount of time set aside for Section 590AA applications that did not proceed, nor for contested sentences that resolved. So add those into the extraordinary number of days set aside for matters that did not proceed. Now, I knew it was bad, but I had to check these statistics when I first did this tally because I don't know how we managed to hear any criminal matters at all. In any given 6-month period, there might be as few as 120 days allocated for all Supreme Court matters. So clearly, many of the days set aside were able to be used. We recycled them, if you like. But we could do that in cases only where the trial collapsed well ahead of time. That is to say, so far in advance of the hearing date that we could reuse it. And if the second trial collapsed, then those numbers went into the figures that I just quoted as well. But repurposing the time was not always an option because of the 100 days set aside for trials that were simply adjourned, more than 60 of those became available only at some point within 2 weeks of the date upon which the trial was meant to start. And on at least 4 occasions, the adjournment occurred within 3 days of what should have been day 1 of the trial. So I stopped doing the statistics at that point. It just got too depressing. And I can't tell you how far out some of those other matters were I can remember a few of them, but I can't, I'm not going to bother going into detail. I think you get the picture. Now, the court, as you know, has adopted some proactive, if not aggressive, approaches to listing, and that's gone some way to salvaging the situation. But all of this really just confirms what I think we've all known for a long time. We didn't need these figures to know that something had to change. And I can assure you that the process of developing the practice direction began a lot earlier than 6 months ago. So it wasn't those figures that prompted this process. It was already underway. It's the problems that we're talking about are problems that we've all known for a long time. Some of you I see here, I've known for a period approaching 40 years, and the same stories recycle. But as a management model, I hope you agree it is indefensible and unsustainable. I mean, even a 50% pass mark, strike rate would not be a pass mark for this sort of operation. But as I've explained, it's less than that. 36 out of 77 is a failure by any standards. And every one of those late changes, every late plea, every adjournment has an impact beyond the circumstances of the case itself, as you know. And perhaps the least important, I mean, you don't have to make it a competition, but perhaps the least important is the impact on the court itself. Now, it's true, these issues are a source of stress, and those of you who attend the criminal reviews will see that manifested from time to time. The running of the criminal list does consume court and registry time that could usefully be used doing other things. But for all of that, the effects on the court are actually confined to a relatively few number of people in the building. And our clearance rates, because of the approaches we've adopted, have remained relatively stable. But gee, it's been hard work. More importantly, the court is conscious of the fact that it is the provider of a service to the community, as are all of you. And in particular, we must always be conscious of the impacts of our work on victims, witnesses, police, defendants, and of course on yourselves, on each other, DPP and defence. And as those of you who have attended reviews over the last year know, I have repeatedly expressed my incomprehension as to how this situation is perpetuated and tolerated by the profession, and in particular by those in private practice. Because repeatedly, at review after review, requests are made for court time for a hearing, for a trial or a sentence, and I refuse them on the basis that the time has already been allocated because these trials have been set down. And as I've explained, it's only later, perhaps within 3 days of the hearing, that we learn, oh no, actually, that time is available. You could have had it. And every one of those refused requests was the denial of an opportunity for someone in the profession to make some money. It is not fair. You are not being fair on each other, and particularly not fair on the junior members of the profession, for whom the opportunity to appear in the Supreme Court is still something special. So I do feel that the more senior members of the profession should be leading the way here on both sides of the equation. And as to those senior members, I'm sure some of them who I see here remember the situation where we could manage this by just having a running list, a list that ran impervious to the convenience of counsel, the wishes of a client, the convenience of a law firm. It used to be done that way, and that's one way of ensuring efficiency. We don't want to, well, it's in fact not efficient. It's one way of ensuring less lost time, but we don't want to go back to that. Apart from its inherent unpopularity with the profession and the police, I should say, that sort of system is not suited to Supreme Court trial work. It is impractical to have a 2-week murder trial listed as a number 3 in a running list of similar trials. And in that way, this practice can be contrasted so clearly with the practice of the district court, which might have many trials that involve only a small number of perhaps more readily available witnesses. I'm just going to divert for a moment. As an aside, there may be a certain class of drug trials that could be fit into a running list. That's a subject for another day. That's something that we'll continue to work on. But I do urge your attention to paragraphs 99 to 101 of the new practice direction, which provides for the possibility of sentences coming on at short notice. Not so much a running list, but just making use or allowing the possibility that you might get a call to say, look, can we do a sentence quickly? Nobody will be forced on under those provisions. But in the meantime, I'd urge you just to tick the box and make yourself available to that system to see if it is of any value. But the problems I'm talking about are bigger than late pleas to a few possession charges, a few trials where possession is charged. And the figures I've quoted demonstrate that. And we're not here, it should be obvious, to attribute blame to anyone for the systemic failures that have been identified. Those figures I quoted earlier might suggest that if we were to try to do that, the blame could probably be distributed fairly evenly. But what has happened is the court has looked inward and challenged the way in which listing has been managed for a long time. And the system that has variously been called a call over or mentions or reviews has always had its limitations. And one obvious one was the way in which information was processed. Practitioners attended call over, sometimes with information, sometimes without, sometimes they'd send an agent with virtually none. That, as you know, is still happening. And even with information, there is a limited opportunity on a busy day of reviews with so many of you waiting to have your matter called on. There's limited opportunity to explore different options. One example that occurs to me is that the prospect of counsel who is briefed to appear in a trial being available for sentences either during or at the conclusion of that trial. Something that you know it happens on circuits all the time and happens on an ad hoc basis when trials are listed here. But the option is rarely explored when the matter is set down in the first place. That's just one brief example. The point being there's limited time during any review for information to be received and assessed and listings to be distributed accordingly. And a good way of demonstrating the inadequacy of the way in which information gathering occurs at the moment is that I commonly make orders for a Form 2 to be filed after we've just listed the matter for sentence. That is a clear case of cart before the horse. So there are no doubt many other failings, both with the systems and those who participate within it. And against that background, the new system has been created. Behold, Practice Direction 5 of 2024, issued by the Chief Justice on the 14th of February and fully operational for over a week now. It's all been made possible by some seismic movement in the registry and the appointment of Ms Bronwyn Curry, who will speak to you soon, as the inaugural Criminal Resolutions Registrar. You will, if you've read the direction, apprehend the nature of her role, and it's all contained in the direction, as are the new requirements for the system which Ms Curry will oversee. As I've said, I'm just not going to read this to you. There will be no substitute for reading it yourself. But as most of you, I'm sure, have already informed yourselves, the Criminal Resolutions Registrar is the cornerstone of the new system. It is a system in which information is shared electronically and retained. Importantly, most matters can now be listed without the need for an appearance in court. And that listing will now be done with the benefit of more time, more information, and in a way which we anticipate will allow everyone's resources to be allocated more efficiently And when I say everyone, I really am, as I've indicated, thinking principally about you, the profession. And as to that profession, lawyers are not known to be enthusiastic about change. Criminal lawyers in particular have been known to be suspicious about anything new. And there's always a concern with a new system that it's going to mean more work. I understand that changes can be particularly threatening for practices that survive on legal aid and by definition operate on tight margins. In truth, Supreme Court crime is likely to represent a relatively small percentage of turnover in most practices, including those. But in any case, those matters should not be a concern. For a start, the types of things that the practice direction requires are things that ought to be happening now anyway. You ought already to have been completing your Form 1 or your Form 2. They've got different names now, but you still just have to fill it out. You ought already be complying with the orders that I make ad hoc and no doubt inefficiently in court on the fly during reviews. Those orders can now be made on a much more considered basis, much more targeted basis, and will be able to cater to your needs much more carefully. It may well be the case that these things now will have to be done in advance of the listing. So we won't have the situation which I just referred to where I list a sentence and then we get the form with all the information relevant to the listing of the sentence a day or two later. These things were always things that should have been done in advance, and now they will be. And the big difference, as I've noted, is that there will no longer be a need to engage an agent or send a member of staff to wait at court for perhaps, back when we used to do it twice a week, an hour and a half or 2 hours, in order to achieve the same outcome. And there is surely an efficiency dividend for everyone in that. I'm repeating myself already, but the other big difference is this opportunity that is afforded under this system to consult and cooperate with each other in order to get the results that benefit everyone. There will be a listing judge. It will still be me for the foreseeable future, but there will still be a judge who can oversee operations, arbitrate on the difficult cases. And there will always need to be some cases that have to come back to court between indictment presentation and dispositive hearing. But they will be few in number. You should be able to get more satisfactory results in less time, and at least that is the result that the new model is calculated to deliver. And the combined effect of all the changes should really improve the margins of everyone who's doing this for a living. If it doesn't, well, a couple of things. One is it probably has to be queried whether it is not the model of the firm or the practice that should be examined. But in any case, there's no claim that this yet to be tried system is going to be perfect. There will be a review, and your feedback is going to be taken seriously and is most welcome. And I know that many of you who participated in the consultation process will affirm that it was a truly meaningful exercise. Indeed, I acknowledge those who have in writing expressed their gratitude to the court for the way in which their feedback was incorporated into the direction as it now reads. I think, for the most part, I'd be prepared to say no reasonable suggestion, well, no suggestion was ignored, and most reasonable suggestions were adopted without the need for any further dialogue. We just changed the draft. Now, whether or not you participated in that process, there will be further opportunity to revise the operation of this direction. But in the meantime, we're all stuck with it. And until it is reviewed, can we please just try to make it work as best we can and take on board the message which I've been repeating for some time now, that you should all be conscious of the effect that your decisions are having on each other. So that's all I want to say. Bronwyn will take it from here. We will have time for questions at the end, but I think she can now render the abstract concrete. Thanks, Bronwyn.
I'd just like to thank you all for joining us this evening to learn a little bit more about the new practice direction for criminal listing in Brisbane. For those of you who don't know me, I am the first resolution registrar, and my contact details are on the slide and are also scattered throughout the practice direction itself, so you'll have no difficulty getting in contact with me. In terms of what I'll be covering this evening, I will start by just covering off on some of the key features. As His Honour Justice Callaghan has already said to you, there is no substitution for reading and familiarising yourself with the practice direction, but I'll try and highlight some key features to get you started. It's a document that you may need to come back to when certain situations arise, and that might be the appropriate time to do so. I'm also going to demonstrate the use of some of the forms for you this evening, so you can see what some of the various options are and the potential drop-downs depending on the way you answer certain questions. And then I'll give you a brief update in relation to the use of the forms so far in the week that we've been utilising them, and the learnings that can be taken from those forms that have been submitted. And then we'll finish off with some questions and answers. So in terms of some of the key features, one of the key differences that you'll note is the reference to expected timelines for the progression of criminal matters through the Supreme Court. Gone are the days of turning up to an indictment presentation and getting your thanks for coming 1 month to do all the things that probably should have been done in the lead up to the presentation of the indictment. Another big ticket item in terms of timeframes relates to paragraph 39 in relation to the provision of a statement of facts. So within 2 weeks of an indictment presentation, if one hasn't been provided already, then you will have a statement of facts, unless, of course, the prosecution makes an application requesting further time, and that might be appropriate to do so if the matter is of some complexity based on the size of the brief. So whilst there are expected timelines in play, there is still scope for appropriate matters to request additional time when needed. Another big ticket item in terms of timeframes is at paragraph 43 in relation to the confirming of instructions within 28 days of certain things happening. So, for instance, provision of the statement of facts, indictment, disclosure, whichever is later of those things. Another key feature is the reduction in the number of reviews for most criminal matters. So in theory, most standard matters should, if they're complying with the practice direction, only require an appearance at the indictment presentation and then at the hearings of substance. There will obviously be exceptions to this, but for the most part, you should see a huge reduction in the amount of time you're spending over in the criminal reviews. And another feature which differs from the old system of online adjournments is the necessity for each party to submit their own form. Now, there are a number of reasons why separate forms rather than one form is submitted. Essentially, it comes down to individual parties are going to be best placed to provide meaningful information regarding their reasons for requiring an adjournment. So both parties might be of the view that some further time is needed before a matter is ready to progress, but their reasons for doing so may be different. And the second reason might come into play with respect to co-accused, and for instance, you might be wanting to highlight certain things on the forms that are sensitive in nature and that you don't necessarily want your co-defendants being aware of at such an early point in the process. So for those reasons, each party will be required to submit a form. The practice direction also includes draft orders that can be utilised to assist the parties with respect to orders for the provision of outlines, submissions, things like that. So that they're scattered throughout the practice direction where appropriate, and you can utilise those really by just inserting your dates once you consult with each other. So that's there as an aid to assist practitioners. And the last feature that I wanted to highlight is the introduction of the Criminal Resolution Registrar role and the necessity to conduct a trial case conference before a matter is set down for trial. And that's set out from paragraph 85 onwards. Now, next I'll move into a demonstration of the adjournment form, Form A, to show you some of the different instances where you would use it. So essentially, it will be used at indictment presentation, even though an appearance is still required. But you're using it in every instance where you need another review date. So it's not necessarily adjourning that in court review in the case of an indictment presentation, but it's foreshadowing the next date that you will need. So you'll use it at indictment presentation and then every review thereafter until such times as you request another form of hearing date. You'll also use it in instances where a matter already has a listing, but you wish to adjourn it. So if a matter has a sentence date, you'd then come back to your Form A if something arose and you were no longer ready to proceed at that time. And then there are appropriate drop-downs around that. So where to find it is on the court website. So all of your forms are contained in the practice direction. The practice direction you can navigate through the court website. At the moment, on the right-hand side, you'll see it's in the latest news, but otherwise you would be accessing it through the court page where you would locate practice directions. Now, you might even find it helpful if you're a practitioner that regularly appears in the Supreme Court. You may even find it helpful just to create a shortcut to your favourites bar to either the practice direction itself or the specific forms. You could do that. So you just click on the star and then that will create a shortcut for you. Now, if we go then to the adjournment form, Form A, you can access all of these straight from the practice direction themselves. So that takes you to your standard adjournment Form A. Now, in order to proceed through, you do have to put an answer wherever there is an asterisk. Now, some of you may have completed a form last week and there was some confusion for some people in relation to indictment numbers. So I've taken that on board, simplified the form now so that you won't be required to do that. But put it if you know it. It helps for identifying which matter you're submitting your form in relation to, if you've got multiple. So just bear with me. So there was also, and it's come up again now on this form. So we've had a little bit of difficulty with the month being expressed before the year, but if you just click on the calendar, you can select the dates using a calendar function. You just click on that. It's to do with the browser settings, but that's something I'll work through in relation to dates. And then we'll, just for demonstration purposes, we'll do it as though we're completing it as the defence representative. No counsel's been briefed on this occasion, for instance. Defendants on bail. Now, you'll see at question 9 here, you've got your different types of adjournments that you might be wanting to do, and the options that then populate based on your response. So to adjourn a review mention. Now this question 10 has confused a few people. It's the party requesting the adjournment, not the person who's filling in the form. So if you're otherwise ready to go, you wouldn't necessarily select that you're requesting an adjournment. There are some questions around committal. Yes, I'm going to stay on the record. Now, in terms of adjournment reasons, there has been an overwhelming use of other. Please have a look at what the options are before selecting other. I kid you not, I have received forms in which the other selected is take instructions, see option 2. So have a look and see if it's there. If it's there, select it, because then you'll get an opportunity to put in the relevant information. If you select other, you've got a very small window to try and explain it. And I think that's what people were genuinely trying to do. They were trying to tell the court far more information about the reason for the adjournment, but you've got scope to do that within these categories. So an example of that might be a particular type of, or particular thing that's being that you're waiting on. Well, that would fall under disclosure. Or another example was someone wanted to have a conference with counsel. Again, that's an option already there. Oh, but it's an additional conference with counsel. Okay, but it's still a conference with counsel. So select conference with counsel and then tell us about that. So, so just trust the process, have a look. If you really don't think that the option covers it, you can use other, but just you can always go back and change if you decide that that's not something that's going to be of use. So we've really had a bit of a look at the adjournment form, so I might take you to one of the other forms now and just have a look at, for instance, at the Form S. So with the, if at indictment presentation, you know that you want to list it for a sentence, you don't need to file a Form A, you can go directly to a Form S. And we have had examples of that already. So again, I'm just going to put an entry in there so we can move through. But it's fairly intuitive, so you don't have to re-enter it if you come back to it. Council. Yes, it's suitable to be brought on the short notice list because it's a quick sentence, knowing that you won't be forced on if you're not available. You've got no outstanding charges. If you select that, then you'll be given the option to provide some more information about that. But on a standard sentence, you'll then have the opportunity to answer if there's still some factual issues to be resolved. You can select that in your form and then we can work towards resolving those factual issues. So if the trajectory is it's going to be listed for a sentence, by all means use your Form S, and then if necessary, we can look at then having a conference if that can't be resolved, or otherwise setting some timelines around resolving that. But that might assist if you have limited availability and you're trying to secure your date. In this instance, we won't go contested. Okay. You'll be asked to give some estimates and then highlight any features the court needs to be aware of at that point. And then you'd hit submit and that would automatically come through. Now, in terms of pre-trial hearings, you've also got your corresponding draft orders, but I think you've probably seen enough of the forms. So I'll just turn now back to so in terms of the forms that have been used to date, in the last week, we've received over 72 adjournment forms, 7 trial requests, 10 pre-trial hearings and 40 sentences. So the uptake has been really, really good. In terms of reviewing these forms, it's been really insightful as some of the answers submitted have allowed for minor changes to be made to the forms to clarify areas of confusion. And I'll continue to monitor the answers that are coming through and make adjustments if I can see that people are having difficulty understanding what's being requested by a certain question. So if you go on and submit a form this week, it might be slightly different to ones you've completed in the past. The other thing I've already spoken about is just the overuse of the selection other. So just reiterating, have a look at what options are available first, just to satisfy yourself before selecting other. Might be an appropriate time to moving to questions if people have some.
We've got some roving mics here. Okay. Anybody wants to
Kick us off?
I love it.
And I'll ask the first question. Have you thought about doing a flow chart so that it's a diagrammatic thing of what happens when? I just know that some people absorb information better that way. We're attempting to do that internally.
Oh, well, you can do it for everyone.
No, I didn't say that, unless there's an order of the court and you're not sitting, so we'll help where we can with respect to
Yeah,
that.
well, that's where you can. Thank you.
Yeah, thanks very much. There's obviously no integration between the court system and these forms, so there's no drop downs. So council's names, other things don't appear in so everybody's just going to have to type them in at this stage. Is there an approach where there will be some integration in the future?
That's a bigger question that touches on the whole of the court technology, I think.
Not in the immediate,
No.
but
So just so people know, we're stepping into the future, but it's still the Stone Age with respect to the forms. So they're just Word documents.
Well, we're not as advanced, for example, as a jurisdiction like Papua New Guinea, which has electronic filing.
Thanks.
That's quite true.
All right.
Hello, I'm so sorry if I missed it. Is there a system or a plan in place to keep members of the public or the media updated on listings, given my impression is a lot of it won't be done in open court?
Well, not really.
hearings of substance. as well.
The listing of matters has already been, I mean, there's already been a lot of administrative listing done, which has not been a matter of done in public. Of course, the substantive hearings will always be published in the law list, and there's no change to that. If there's a problem in that regard, like I say, any feedback, any suggestions are welcome. But so long as the substantive hearing continues to be a matter of public record, I'm not sure that the sorts of things we're talking about really need to be, except when they become a problem, in which case they will come back to the reviews. I'm not sure that the fact that someone needs a 4-week adjournment to take instructions from counsel really needs to be something done in open court. Controversial adjournments, high-profile matters will still be matters, I think, that will still be referred back to the, well, there'll be a lot of matters that get referred back to the listings judge for determination. I anticipate any of the controversial ones will be there, but if that becomes an issue, then we'll certainly look at it.
And the court actually has a media relations person, so most of the media keep up with when things are listed by making a request to them.
Yeah, I do get notified too of matters in which there is particular media interest. So, and I imagine, well, in terms of victims of crime, for example, I mean, that's where the DPP would be keeping them posted.
Keep them up to date.
Yeah.
So it's just members of the public, and members of the public sometimes reach out to us and we refer them back to the court because it's a matter of public record when something is listed, and then there's an area within the court that deals with that directly.
Does that answer the question?
Are self-represented litigants going to be expected to use these forms, or how's that process going to work for them?
They're welcome to, but the self-represented litigants are, challenged to every aspect of the administration of justice. I predict that review dates will become self-rep dates.
Though we have a number of really experienced self-represented litigants who are very familiar with the court processes,
Yeah.
so I expect that some of them will use this to their advantage.
Yeah, as I say, they're welcome to, but
Just not those in custody.
no. There was a question over, or a couple over here, Todd.
What's the anticipated turnaround for getting responses in relation to lodging the sentence forms and the trial forms? Because I know dates, availability dates, counsel practitioners, DPP change on a daily basis. So if we're getting responses back 3 days later, those availability dates are usually not available anymore.
I'll let Bronwyn have first crack at that, and then I'll have something to say.
Provided the dates are by consent. So if 2 forms are received for a sentence listing, you should be getting it pretty much straight away. There shouldn't be a delay. There are currently some outstanding sentence requests, and it's because I've received them from one party and without consent from the other. So if you're really wanting a timely turnaround, talk to your opponent and ensure that you're aligned with your dates, and you'll get them really as quickly as possible. We turned one around this morning in relation to a pretrial hearing. Within minutes, the order was made as per draft. So it can be done quite timely, and it really depends on the cooperation of the parties.
And that's what I was going to add, was the to harken back to what I said earlier about the opportunity for collaboration and cooperation in the profession. And now you've got time to do that. You can do that over the course of a day, rather than trying to scramble and match up diaries at the bar table in the course of a review. It won't take much by way of communication between the parties, I wouldn't have thought, to work out what is available and work out options, give them to Bronwyn, and we'll try to achieve the greatest happiness for the greatest number.
And again, from the prosecution point of view, if you let us know what you're going to put on the form as you're submitting it, then we're in a position to respond to that rather than waiting for the form to come out to respond. I had one question. You spoke about one co-offender, Bron, not being seen by the other. So there isn't a requirement that all forms be visible to the opposite side?
No, but they would be sent back to, so for instance, for defendant A would be provided back to the prosecution and defendant A's representatives, but they would be aware of those issues, but not necessarily the other defendants. So there will.
So I have to say not necessarily. Does that mean some forms will and some forms won't?
No, unless there was, for instance, a joint pre-trial application, then that would be appropriate to be shared if it was thought necessary. But for the most part, that shouldn't, I wouldn't envisage that would be necessary.
Having been familiar with the forms, how will you know it's a joint application? Because obviously that, unless somebody puts in the other form or one of the free text forms that it's actually a joint application by both sides. So I'm thinking like a 590. So one co-offender might be challenging a search, for example.
Yes.
And so you're just sending that form to the prosecution and back to the person who says we're challenging the search. The co-offender might also want to challenge the search. But if we're not exchanging those forms, how will people know that?
Well, I mean, sorry, Bronwyn, but you'll be, that sort of situation, you'll be coordinating. Bronwyn's going to need to know from both parties what they're challenging. So
in saying that the availability is going to be different. So that scenario that you've described, Todd, is something that we've dealt with in the last week, where, for instance, there was 3 parties, 3 of which all want to make a basher application, 2 of which want various different evidentiary matters excluded. Now, in terms of the availability of counsel, that was quite challenging, but we were able to then, based on the information provided on the individual forms, list those various hearing dates, when the only one that really required the mutual availability was going to be the joint application. And that came through from individual defendants' forms, but there was certainly still reference to co-offenders and availability dates. But I then had to liaise with all of the parties in relation to the joint hearing, and then could liaise individually with respect to hearings that only related to their defendant.
Just from a defence perspective, I saw from the form it had a question, is counsel briefed? Is it the desire that these forms are filled out by defence solicitors rather than counsel, or it doesn't matter for your purposes who fills out the form so long as it's done?
The latter, as long as it's done. If you've got good communication with your counsel, you've got their availability, I think it's appropriate for the solicitor to do that. You as counsel might want to weigh into that if your dates are moving, or the form might be the starting point and then we have to go back and do a little bit of back forth to find dates that work for everyone. And at that point, that might be where counsel want to get involved and respond directly, because it's their diary that's moving and changing at a rapid rate. So, but from the court perspective, don't really mind who fills it in, provided it's filled in with meaningful information.
And not two, I assume, one from counsel, one from solicitor.
No, that's not necessary.
Well, if they say the same thing, it's okay. We might just take one or two more. I think we're approaching time, if there are one or two more.
If I might just ask a follow-up question from Michael's. Bronwyn, when you mentioned that there might, during the course of the day, be some further liaising that's necessary, would we expect that will come by way of telephone calls, and if so, directly to counsel or to solicitors, or will that be by way of emails?
I envisage email in the first instance, and with counsel copied in. Obviously, certain counsel might be in court and not able to respond immediately, and we'll monitor that as it goes. But in saying that, my contact details are available. If people need to phone me, that's okay. But generally speaking, we'll deal with it via email so that those who need to know what's going on.
Last one, Ed.
This might actually be more a question for Todd, but probably
I'm fine with that.
Others can weigh in. Where there's a focus on a case conference with a view to resolution, be that a case conference prior to a 590 or potentially in advance of a trial, is it assumed, or is it going to be the case that the person appearing for the Crown is going to have the authority to actually make some decisions in that case conference, or is it going to be one of those situations where there's a possible resolution, but there needs to be your authority or something else? And I suppose the same issue might occur where you've got a client in custody and you don't necessarily have instructions in that moment or in that conference to affect the resolution, whatever that might be. So I suppose that's both a question and a comment.
My initial reaction, though, would be that a case conference doesn't have to sort of start and end within half an hour. It might be an ongoing process. I think, we want to do it as efficiently as possible, but case-by-case basis, that you're always going to have situations where you're not going to be able to wrap things up in the one session. It doesn't mean the case conference is over. It's not that there's no time limit provided. But sorry, Todd, you...
No, you don't need to be sorry. It's your house. From our perspective, there's obviously certain things that we need to do before we can make decisions. And so Supreme Court, for example, if you're coming in saying we'll plead to manslaughter on a particular basis, well, obviously that has to come back to the Directorate. That involves consultation we're required to under the VOCA Act and under our guidelines. I would be hopeful in those sort of circumstances that those submissions or negotiations are in advance of the case conference, and the case conference might be to facilitate some of the things around the edges that need to be done, because we also appreciate you need clients' instructions with respect to certain things. I think the initiative is to say if there are opportunities to resolve things, then we should be engaging in that. And I think actually the case conference before Bron is probably the last of them, right, that we get to. I think certainly in some of those instances where it's a contested sentence, is it really a contested sentence? It's about forcing us both to have our counsel involved and looking at them and saying, well, I don't agree with that, but is that actually a contested sentence? Or my client won't accept this. Well, the prosecutor turns up and says, well, we don't care that your client doesn't, we don't say that has an impact on the sentence. They seem to be the most things that occur on the eve of the court. It's listed for a sentence. My client doesn't accept these things. And we say, well, they don't really matter to us. Or the prosecutor turns up and says, this is the matter we want to rely upon, and you need to go and get instructions on that specific matter because you didn't think it was such an important thing in the sentence. So, but Bron, how many case conferences have you had?
5, I would think. And they've been in various forms. So we've done some simple ones over the phone. We've done one via Teams. We've had a couple in where we've done them in court in person.
How successful were you at getting counsel from both sides to participate in that?
Always.
All right, so.
Sorry, no. With the exception of one, there was a solicitor appeared, but that matter ultimately didn't necessarily resolve the contest within the conference, but within days of that conference, it was able to be resolved.
And the sort of matters that those 5 were about, I'm aware a couple of them were sentences.
Yes. Another one instance was from indictment presentation, the defence turned up and requested a trial listing straight off the bat. That matter was set down for case conference. What became apparent very early on was that there were submissions to be made if submissions were accepted. So that conference took a turn and really became about timetabling for a whole host of things to happen that will, I suspect, mean that matter won't ultimately be a trial in the second half of the year at all. It'll most likely resolve. So they're all a little bit different in so far as the conferences that have been done to date have been referrals from the judge, as opposed to one specifically falling under the practice direction in order to obtain a trial listing. But there've been ones where it was thought perhaps it would help, or it would just, even if it was an assistance in terms of the timetabling or turning minds to other pre-trial matters. For instance, there was a trial matter conferenced in which 2 pre-trial issues were identified that might otherwise have not been identified with sufficient time for that trial to then proceed. So there have been some small wins along the way so far.
So each of them has been a positive outcome from a listings point of view?
From the court perspective, yes.
Was there anything else you wanted to add? I'm going to give you the last say. I think we're going to wrap it up now. Was there anything arising out of any of those that you wanted to finish off on? Okay. Well, I will wrap it up now. Thank you all. I reiterate what I said about feedback. Please, even if you just make a note of it, and when we have a more formal sort of a review of it, let us know. I do foresee problems, of course. I haven't shared those, but I have to say I don't really foresee them emanating from anyone in this room. There are, as you know, outliers in the profession who will challenge the new system, but at least they will be, left exposed, I think, under this regime. So thank you all for your attendance and for your anticipated cooperation, and we'll leave it at that. Good night. That's